Start. The point of law which has necessitated the reference of this criminal miscellaneous application to a division bench may be formulated in the following terms. Stop. Para. Is this High Court empowered to revoke, review, recall, or alter its own earlier decision in a criminal revision and rehear the same? Stop. The facts which deserve notice for the limited purpose of this application may now be surveyed. Stop. By his order dated, the Executive Magistrate First Class in proceedings under Section 145 Criminal Procedure Code held that Karnail Singh and others were in possession of the land in dispute on the 6th May 1967 and directed the delivery of the same to them. Stop. Against this order, respondents in the present criminal miscellaneous application went up in revision to the learned sessions judge, who, by his order dated 1st April 1968, made a recommendation to the High Court for the acceptance of the revision on the basis of the reasons given therein. Stop. It was recommended that the order of the learned magistrate be set aside and the possession of the land be ordered to be delivered to respondents in the present criminal miscellaneous application. Stop. Para. The learned sessions judge had directed that the parties, if they so desire, may appear in the High Court. Stop. However, it appears that the matter came up before the registrar on the 13 May 1968 and that none of the parties was then present. Stop. Notices on that date were directed to be issued and all the parties were served. Stop. Some of the respondents therein, amongst them the present petitioners in this application, did not put in any appearance and consequently on the actual date notices were issued to them by registered post acknowledgement due intimating thereby that the revision would be heard by this court on the 31st July 1968. Stop. On the said date, the revision came up for hearing and it was found that actual date notices had not come back duly served. Stop. The state was represented through counsel and the recommendation was not opposed on its behalf. Stop. The learned single judge notices that some remark was made that the respondents, other than the state, were no longer interested in the matter on account of the civil litigation having been compromised in the High Court and consequently, when the matter came up before court, it was pleased to pass the order that this revision is reported for acceptance and is not opposed. Stop. Para. For the reasons given by the learned sessions judge, the revision is accepted, the order of the learned magistrate is set aside, and it is ordered that possession of the land, which is the subject matter of the present proceedings, be delivered to the petitioner's tenants. Stop. Para. The present criminal miscellaneous application was then moved under Section 561A Criminal Procedure Code. Stop. It was averred therein that the actual date notices issued by this court for appearance to them on the 31st July 1968 were actually delivered to them on the 4th of August 1968 and the reports on the registered covers dated the 31st July 1968 clearly show that none of the present applicants were present in the village on that day. Stop. It was further averred that the order dated the 1st August 1968, which was passed without affording any opportunity of hearing to them, is gravely prejudicial to their interests and the same be vacated. Stop. Para. Notices of the present application was issued to the respondents and accepted on their behalf by the council, and meanwhile the operation of the order dated 1st August 1968 was stayed stopped. At the hearing of the application, it was contended on behalf of Lal Singh etc. respondents that there is no power in this High Court for a review of its earlier order dated the 1st August 1968, and the same having become final could not now be interfered with. Stop. In view of the importance of the question involved, the court, for the reasons given in the relevant order, referred this case for decision by a larger bench, and this is how the matter is before us. Stop.